Hi there, this is Jonathan Ginsberg. I'm an Atlanta area personal bankruptcy attorney, and today I'd like to talk to you about what is called Murphy's Law. And if you've not heard of that, what it basically means that if something bad can happen, it will happen. In the bankruptcy context, where this comes into play is I've seen more than a few cases where somebody is not entirely accurate with their bankruptcy schedules. They don't give their attorney all the information they should. And that's the one case where the trustee decides to double check all the facts, or that's the one case where you have an angry creditor who wants to make a huge deal about everything you list in your case. And specifically what you've got to be really careful about are cases where you have transferred money to anybody really within the last couple of years prior to filing, and especially if you've given money to what are called insiders, a parent, a sibling, a child. Because those transfers can be considered preferential transfers, or they can be considered fraudulent transfers. And in a best case situation, the trustee can demand that the recipient, your mom or dad or your brother, sister, child, whomever, give that money back. And it's certainly not a real pleasant situation when your sibling gets a letter from a trustee saying that $3,000 your brother gave you 2 months ago, you've got to give it back. So you need to be very, very concerned about any kind of transfer. Make sure your lawyer knows about it. And equally important, it does not matter if you transferred the money and then your sibling or whomever insider gave that money back to you. The act of actually transferring it is the problem. If they gave it back to you, that doesn't erase the problem. So I've had situations where somebody transferred, let's say, $10,000 to his brother, realized he had to file bankruptcy, the brother gave the money back. My client did not list the transfer in the bankruptcy petition. It turned out that was a problem because you have to reveal the transfer even if you got the money back. So let your lawyer advise you about whether or not it's relevant or important, but you need to reveal to your lawyer any type of transfers. And I'm getting to the point now where I tell my clients, let me see the last year, or in some cases 2 years of bank statements, and if I see large transfers, and large is really anything over $600, $800, I'm going to want an explanation and maybe a copy of the check. Ideally, I get the bank statement along with copies of checks, and if I see payments going to a relative or to the same person over and over and over, I need to know what's going on with that. In a similar vein, if you have bank accounts that you don't consider yours, it's your mom's bank account, but your name is on it. You are self-employed and it's, Joe Smith and Company, but it's your business account. You don't use it for personal expenses. It doesn't matter. You have to reveal that stuff. So any bank account that has got your name on it, or that you have any access to, that you can have control over. It could be your child's bank account. It could be anything that you have, your name is on that account, or you have access to it. That needs to be revealed to your lawyer. And again, your lawyer can tell you whether or not that is something that needs to be included in the petition schedules or not. But you cannot make these decisions on your own. And I think that's where people get in trouble, is they sort of decide, well, this is more trouble than it's worth. It's just going to raise a bunch of questions. No one's going to find out. They don't reveal it, and then that's the one case where you have a trustee who starts snooping around and wants copies of everything, or you have an angry ex-wife or an ex-business partner. So my advice to you would be, when you're thinking about filing bankruptcy, reveal everything you possibly can think of, that anything associated with you, your name, anything that you have any interest or control over, let your lawyer know about it. Your lawyer can advise you about whether this needs to be revealed and in what form it needs to be revealed, but don't make that decision for your lawyer, because the last thing you want to be doing is appearing in front of a judge or a trustee and having to explain why you did not list something. It's very uncomfortable, and if you say to the judge, well, I didn't think it was important, I didn't think it was really relevant, that doesn't hold water with the judge, and it could really damage your credibility, and you may need that credibility to ask the judge to believe something else, that you're going to have the money to pay your mortgage, you're going to have the money to pay some other domestic support obligation, something like that. So you want to come across and be completely truthful, reveal everything. And again, your lawyer is going to have the experience to know what needs to be listed and what needs to be available in case somebody asks about it. But you don't want to just assume that it's not important, or that because you got paid back you don't have to list it. That is not a decision that you as a bankruptcy debtor needs to be making. Let your lawyer advise you. That's what you're paying him for. Let him or her advise you about that. If you found this useful, please give it a thumbs up on YouTube or a like on Facebook. Please subscribe to our channels, our YouTube channel and our Facebook page. And of course, if there's any questions you've got about personal bankruptcy in the Atlanta area, please do not hesitate to call me. Jonathan Ginsberg here. Wish you well and talk to you next time.